Welcome back to our law snippet, and today we will be discussing a very recent judgment delivered by the Supreme Court, which is Vinod Dua versus Singh, right? And you must be aware of who is Mr. Vinod Dua, and he's an acclaimed media personality, right? He's a Padma Shri awardee and a winner of many lifetime achievement awards in the media. In the month of March 2020, he has made certain critical comments about COVID management and lockdown. In the meanwhile, Supreme Court gave direction in Alok Srivastava case on 31st of March 2020 that no media should telecast unverified news. I want to clarify to all of you that Mr. Dua's program was telecasted before the judgment in Alok Srivastava case. One FIR was filed against Mr. Dua, alleging that he was trying to spread hatred and affecting public order and peace. So case under section 124A of IPC was registered, right? And besides, it was alleged that he had violated the orders of Alok Srivastava case, right? And hence, section 60 of Disaster Management Act and section 188 of IPC was also added in the FIR. Mr. Dua sought for quashing of the FIR. He made two prayers. One, quashing of FIR. And two, direction to lower court that before FIR, there should be a preliminary inquiry for a media person with 10 years of experience. So this is the background of the case, right? Now, let's discuss this case, and I would like to share my screen so that you would be able to see my presentation, which I have prepared for you guys. Just give me a moment. Yes, I hope it's visible. All right, because we are dealing with this technology, and I'm sure this is visible now. All right, so this is Vinod Dua versus Union of India, and it's a 2020 writ petition. And we will also go into the impact assessment of this judgment, right? And this judgment is extremely important for CLAT 2021. It was two judges bench, Justice UU Lalit and Justice Vinod Saran. It's a constitution. This judgment has referred many constitution bench judgments, right? So let's see what it is. This is an important case in criminal law as well as constitutional law, right? So this has referred Lalita Kumari versus Government of Uttar Pradesh, Ramji Lal Modi versus State of UP, Mahendra Singh Dhoni versus Yara Kuntla Sham Sundar, Romesh Thapa versus State of Madras, Daryao versus the State of UP, Kedarnath Singh versus State of Bihar, the Superintendent versus Ram Manohar Lohia, and many more. So these are the most important judgments. So let's move on. So there were prayers which were made by the petitioners. What were these? First, the statements given are within the exercise of right of freedom of speech and expression as it is covered under explanation 2 and 3 of section 124 IPC, 124A IPC, and exceptions to section 50 of IPC, 505 of IPC. I'm really sorry about that. So the petitioner has not violated orders of the court in Alok Srivastava versus State case because petitioner's statements were telecasted before the state judgment. The third point, the third prayer that was made by the petitioner was that the section 188 of IPC is not maintainable because there is no complaint as per section 195 of the CRPC, and also petitioner has not violated Alok Srivastava case. It's a state. So petitioner prayed for two things which I have already mentioned in the beginning. That first, to quash the FIR, which was registered against him and which was also paid. And second, that some criteria be decided so that inquiry needs to be done by a board before registering FIR against a media person of 10 years of experience, right? So that was the prayer. Now the next slide. Now let's see what was the decision of the court, right? Now the first issue was whether quashing of FIR can be considered under Article 32 of the Constitution instead of Section 482 of CRPC when final form has not been submitted as per Section 173 of CRPC, right? So there are two views to this question. We know we have studied Arnab Goswami case, right, in our classes, in Lex Templum classes. So we know in Arnab Goswami case and in Amish Devgan case, which also we discussed in lot of details, the court has basically denied to consider the quashing of the FIR through writ and advised the parties to exhaust the provisions under the code, that is Section 482 of CRPC. On the other hand, Priya Prakash Warrior, we all know a girl, she got famous for of her acting on Instagram. So there was case on her name also. So Priya Prakash Warrior, the Supreme Court quashed FIR considering the prayer under Article 32, right? So moving on to the next slide. So how the court should decide, right? The court decided to discuss the preliminary objections to it. Court referred to Romesh Thapar versus the State of Madras, which basically held that court is thus constituted the protector and guarantor of fundamental rights, and it cannot consistently with the responsibilities so laid upon it refuse to entertain applications seeking protection against infringements of such rights. Similarly, there was another case in Daryao versus State of UP. It was held that it is a privilege and the duty of this court to uphold fundamental rights, right? Now, court held that by referring to these cases, in major cases of deprivation of liberty, Supreme Court has entertained petitions under Article 32 of the Constitution. Just a second. Yeah, we are on the right slide. Okay, so the Supreme Court has entertained petitions under Article 32 of the Constitution, and hence the preliminary objection does not have any ground, right? And besides, the petitioners prayed relief for protection of his fundamental rights under Article 19(1)(a), and this prayer can be addressed only through a writ prayer, right, at the Supreme Court, and hence the preliminary objection, the court said that the preliminary objection needs to be rejected, right? So moving on to the next slide. Now the second issue was whether Section 124A of IPC, Section 188 of IPC are revealed in the FIR. Now in this case, the court referred Kedar Nath Singh versus State of Bihar, which this is an important case, which decided the scope of Section 124 of IPC. And the court held that the provisions of the Sections 124A read as a whole, along with the explanations, make it reasonably clear that the sections aim at rendering penal only such activities as would be intended or have a tendency to create disorder or disturbance of public peace by resort to violence. And it is only when the words written or spoken which have the pernicious tendency or intention of creating public disorder or disturbance of law and order that the law steps in to prevent such activities in the interest of public order. तो केदारनाथ केस में क्या बोला था? केदारनाथ केस में यही बोला था कि जो भी प्रोविजंस है सेक्शन 124A के, जब आप उसको पढ़ोगे उसके एक्सप्लेनेशंस के साथ, जो एक्सप्लेनेशन दिए है 124A के साथ, अगर उसको जब पढ़ोगे तो वो हमें एक चीज क्लियर करता है कि वो ये बोलता है कि जो ये सेक्शन है 124 है, इट इज ट्राइंग, इट इज एमिंग कि वो उन्हीं एक्टिविटीज को पीनल बनाए जो एक्चुअली जिनका इंटेंशन है, जिनकी टेंडेंसी है कि वो एक पब्लिक पीस को डिस्टर्ब कर रहा है, या जिसकी वजह से कोई वायलेंस हो रही है या कोई डिसऑर्डर क्रिएट हो रहा है सोसाइटी में, तो वही चीजों को पीनलाइज करो। एंड जब आप ऐसी कोई चीजें बोलते हो, आप मुंह से बोलते हो वर्ड्स, या आपने कहीं लिखा है, राइट, जिसकी वजह से सोसाइटी में लॉ एंड ऑर्डर के इश्यूज हो सकते हैं, पब्लिक डिसऑर्डर कॉज हो सकता है, या सोसाइटी में डिस्टर्बेंस आ सकता है, तो उस टाइम क्या होगा, जो ये लॉ है दैट विल स्टेप इन सो दैट दीज काइंड ऑफ एक्टिविटीज, ये जो एक्टिविटीज है उनको प्रिवेंट करने के लिए, ठीक है। तो that's what it meant. Then moving on to the next slide. Now, the court referred to S. Rangarajan versus P. Jagjivan Ram, right, versus State of Maharashtra. Court held that the public discussion with people's participation is a basic feature and a rational process of democracy. And the intention has to be judged primarily by the language of the book and the circumstances in which the book was written and published. The content needs to be considered as a whole, right? Then the court also referred to Manzar Said. Yes, both the cases they referred. Let's move on to the next slide. Then in Patricia Mukim, the court, Patricia Mukim versus State of Meghalaya, court considered the intention while deciding whether a Facebook post, right, can spread hatred in the community. And court decided that a statement would attract section 124A of IPC if first, expression of disapprobation of actions of government, not made with an intent to incite people, not meant to create disorder in the society. So, as per ratio of Kedarnath and Patricia Mukim, the petitioner has not committed a crime under section 124A of IPC, right? So, charging him under section 124A would be violative of fundamental right under article 19(1)(a). Hence, the FIR is liable to be quashed. Besides, section 188 of IPC is not applicable because Alok Shrivastava judgment came after the telecast of the video by the petitioner. So, as none of the offenses are made out, the FIR stands quashed. Right? So, moving on to the next slide. Right? Now, let's go to the second question. Whether it is possible to cause preliminary inquiry before registration of FIR for certain category of people, right? So court referred to two judgments. One is Jacob Matthew and another one is Lalita Kumari. And as per Jacob Matthew, before a medical professional is prosecuted for negligence in criminal law, some threshold requirements ought to be satisfied. Otherwise, an unwarranted prosecution may not only result in great prejudice to the concerned medical professional, but would also not instill a sense of confidence in the medical professionals for discharging their duties. And then it also referred to Lalita Kumari case. As per Lalita Kumari, we all know that preliminary inquiry before registration of FIR is possible only in these cases: matrimonial disputes or family disputes, commercial offenses, medical negligence cases, corruption cases, and the cases where there is delay. So, what was the decision of the court? So, in view of the above two judgments, that is Jacob Matthew and Lalita Kumari, it is not possible to have a recourse to preliminary inquiry before registration of FIR, as the circumstances of preliminary inquiry is already laid down in Lalita Kumari. So what was the conclusion? FIR was quashed, first prayer was granted, and second, the preliminary inquiry before registration of FIR against media personnel of 10 years experience was not granted. Right? So just give me a minute. So that is it for today. We will meet next time on Law Snippets with another important case or another important matter that discussion with all of you. So thank you for today. Thank you for listening me. And if you guys have any feedback, please let us know. Thank you again. Take care and goodbye.